File 23-21562-FH, People versus Lisa Marie Cox. We are here today for a pretrial in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Your Honor, good morning. Elias Muad, appearing on behalf of Lisa Marie Cox.
All right, and let's see, Mr. Muad, I believe you said that you've reached a plea agreement in this case. Is that right?
Correct, Your Honor. The plea agreement would be a dismissal of count 1. That is the controlled substance delivery and manufacture. However, my client would plead guilty to count 2 under a plea agreement that Ms. McClure and I have worked out. There's a recommended sentence of no upfront incarceration. And I believe that is the full plea agreement.
And I believe we did forward a signed plea agreement to Ms. Clark in this case. So I don't know if it's in the court file or not.
I do have a copy of that, although I would just indicate for the record that my copy is only signed by Ms. McClure.
Oh, okay. I do have one here that is signed by Ms. Cox and myself. If we want to do the plea, and I can get this email to you afterwards.
I have it as well. I can just forward it right now. It'll probably be a little quicker. I have it pulled up. So
thanks, Phoebe. Thank you.
All right, that's fine. Ms. Cox, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Lisa Marie Cox?
Yes.
Ms. Cox, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, furnishing contraband to a prisoner?
Yes, I am.
I'm sorry, your audio was not clear. What was your answer?
I said, yes, I am. I'm sorry.
All right. Are you satisfied with Mr. Muad and the advice that he's given you?
Yes.
You understand that the maximum possible penalty for that offense is 5 years in prison?
Yes, I do.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than the recommendation that has been addressed today on the record. Is that correct, Ms. Muir?
that's correct.
That is correct, Judge.
Is that also your understanding, Ms. Cox?
Yes, it is.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Cox, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I do.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No.
I'm sorry, I was not able to hear your answer.
No, I have no questions. Sorry.
Okay. And do you understand that you're giving those rights up?
Yes, I am. Yes, I do. Sorry.
How do you wish to plead then to the charge that on or about June 12, 2022, in Adrian Township, Lenawee County, Michigan, that you did commit the offense of furnishing contraband to a prisoner in prison.
Plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
You understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea.
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Cox to plead guilty?
No, Your Honor.
No, Your Honor.
Ms. Cox, other than as we've addressed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, he has not.
Is it your own choice to plead guilty today?
Yes, it is.
Mr. Mawad, would you like to establish the factual basis?
I will. Ms. Cox, I'm going to ask you a couple of questions. On June 12th of 2022, you were in Adrian Township in the county of Lenawee, correct?
Yes, I was.
And on that date, in Adrian Township, Lenawee County, you did either sell, give, or furnish, either directly or indirectly, a controlled substance called buprenorphine. That's buprenorphine, which is a controlled substance to a prisoner at the correctional facility in Adrian Township, Michigan, correct?
Yes.
All right. I think it meets all the elements, Judge.
Just if I could just voir dire about some specifics of this, Judge.
Yep.
Okay. Ms. Cox, did you in fact go to Gus Harrison in Madison Township?
Yes, I did.
And were you visiting a prisoner Tuttle?
Yes.
Okay. And did you directly hand him strips of, was it Suboxone?
I don't know what it was, but yes.
Okay. Controlled substances though.
Yes, I handing something. I just didn't know what was in the pack.
Okay.
Yes.
And then he was able to actually take that into the prison after your visit?
No, he got caught going back into the prison.
But I mean, he was going into the prison with them.
Yes. Yes.
Okay. All right. I'm satisfied, Judge.
So am I, Judge.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Cox has had full knowledge of her rights. She has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 11th at 8:15, if that works.
That'll work, Judge, and that'll work perfect because I start trials in February, so we'll get it done. Thank you very much. Thank you.
Okay. Ms. Cox, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. And let's see, Mr. Stevenson, you want me to place you in a breakout session so you can get her contact information?
Yes, Your Honor.
Okay, Ms. Cox, I'm going to put you in a breakout session with Mr. Stevenson from the probation office so he can get your information and give you instructions about what you need to do with them.
Okay. Thank you.
All right. All right, Ms. Cox, if you have any questions, please give me a call. Thank you. And thank you, Ms. McClure, also. Okay.
Yep.
Thank you. Okay.
All right, Ms. Underwood, are you ready to proceed with Mr. Binder?
Your Honor, okay. I think we have something worked out, Your Honor.
Okay,
but-
let me call the case first.
Thank you.
Or do you need to speak with somebody before we do that?
No, I think I'm going to do something different than what I thought I was going to do, but it's okay.
All right, we're on the record then in file 23-21577-FH People versus Ryan Scott Binder. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
BB McClure on behalf of the people.
Rhonda Underwood, on behalf of Mr. Binder, Your Honor.
And Ms. Underwood, where do we stand with Mr. Binder's case today?
We're in the process of working out a plea, Your Honor. And I just have to check on one kind of big aspect about it. And I'd like to talk to the MDOC about that before I actually take the plea, Your Honor, so I can properly advise my client. So I just would like a very brief adjournment, Your Honor. But this matter, I believe, is headed towards resolution.
All right, Ms. McClure, anything we need to address from the people's side?
I guess not. I don't know. What's the issue, Rhonda? I thought we were gonna have a plea today. I'm sorry.
Well, the issue is the rest of the concurrent issue, Phoebe, and I just want to make sure where I am on that. I believe it would be a concurrent sentence, but I want to be able to tell Mr. Binder, obviously.
Okay.
Ms. Underwood, I can do December 27th if that is enough time.
That's fine with me, Your Honor.
All right, so we'll set it for December 27th at 8:15 a.m. Ms. Underwood, would you do a stipulation in order for that?
With Ms. McClure's permission, Your Honor.
Yep, that's fine.
Thank you, Your Honor. And Mr. Binder, I will be back on the 27th. Okay?
Okay.
Thank you.
All right, Mr. Binder, you can let the officer that's with you know that you're done with court.
All I gotta do is just walk out of the room.
Okay. All right, Mr. Dagger, Margosian, Mr. Lester is here. Did you need a breakout session with him?
No, Your Honor.
Okay. Ms. Underwood, we have, let's see, London Johnson from the jail. Do you need a breakout session with him? Or see Mr. Glazers?
Who is it, Your Honor?
I'm handling London Johnson, Your Honor.
Yeah, he was a pickup on a warrant. Do you need to speak with him, Mr. Glazer?
Maybe for just a second. It won't take very long.
Okay, let me put you in a breakout session real quick, and then we'll get to Mr. Lester's case. Mr. Fryer, you're gonna need a breakout session with Mr. or Ms. Walden. No, you're not. She's on Zoom. So, okay, let me do this one and then I'll get to yours. Okay, we are on the record in file 23-21516-FH, People versus Donald Raymond Lamont Lester. We are for a pretrial conference in this case. And okay. We are proceeding today by video conference.
Your Honor,
Mr. Glazer, I'm on the record in another case right now. What's the issue?
That didn't work, whenever you tried to put it in the room.
All right, let me try again. Okay. All right. Let me first ask the attorneys to place their appearance on the record in the People versus Lester case, beginning with Ms. McClure.
BB McClure on behalf of the people.
Yeah, good morning, Michael Dagger Margosian for Mr. Lester.
All right, and Mr. Dagger Margosian, where do we stand with Mr. Lester's case today?
Your Honor, I'm going to ask the court to do two things. I'm going to address bond in a moment, but on the case itself, in reviewing it, it appears as though there was a preliminary exam. We still need that transcript. In speaking with Mr. Lester, my understanding is that there probably will be some evidentiary issues that I want the court to weigh in on and make a decision. But ultimately, this case probably will be litigated. Mr. Lester has been in jail since the date of this incident, which is over 4 months at this point. Obviously, pre-trial, obviously before conviction and presumption of innocence does apply. I think it would be inappropriate for him to have to remain in jail while fighting this case. And this is the count one is a non-assaultive charge. And in reviewing the case and watching the video, counts 2 and 3, the R&Os are suspect at best, I would put it at this point. So I'm asking the court to change Mr. Lester's bond to a PR to allow him to have better communication with me and be on the outside of jail while fighting his case.
All right, Ms. Meir, anything you would like to say with respect to the issue of bond?
Judge, we did just have a bond review, and we did reduce the bond to $5,000, cash assurity with a GPS tether. There was a prelim in this case. I think with it being bound over, there wasn't anything to suggest that there was anything to suggest that Mr. Lester wouldn't be convicted of these charges. And that obviously can be considered here at in a bond review. I don't think another review of bond or another reduction of bond is appropriate in this case.
Your Honor, may I just respond briefly?
Go ahead.
The 5,000, it might as well be 5 million. I mean, he doesn't have any money to post at this point. And I disagree with Ms. Meir as to the convictions. And if that is, I mean, yes, that is a factor of bond, but it's minimal at best. Obviously, the two big factors that a court takes into account is safety to community and appearance to court. And I don't have any indication that those are implicated here.
Great. Well, one concern I have is that the information lists his address is unknown. So where would he be living?
1121 Division Street.
All
I
right.
just been in contact with a friend of mine. She's been writing. Her name is Danielle Heath. And my son is here in this town. This is his last year of high school, Mr. O'Saban. He goes to Adrian High School. His last name is Dante. His first name is Dante. His last name is Lester. This is his last year. No.
All right. So what I'll say, Mr. Dagger Margosian, is I am willing to consider it, but not simply based on what I have in terms of argument here today. So if you want to schedule a hearing and have some more developed information that goes through the actual bond factors, I appreciate that he challenges that he doesn't think he's going to be convicted. But at this point, I don't have anything to analyze, anything in front of me to analyze with respect to that issue in front of that. I don't have solid information about where he'd be living, who he'd be living with, and all of the other bond factors that I would need to consider to make a thorough determination about this. So I'm going to say I'm going to deny your request for now, but I am willing to consider it if we have again more developed information that addresses more of the relevant bond factors.
I'll file a motion to the court.
All right.
Speak with you whenever you get a chance after this too. Whenever you get a chance, it don't matter whatever day you can pick. Because this is an unsigned warrant right here in front of my face, right here, unsigned by a police officer.
All right. Let the record reflect I've muted Mr. Lester's device. I will adjourn this to January 24th at 8:15. Mr. Dagger Margosian, if you would like to schedule your bond hearing before that, you're welcome to schedule it at any time that we have available.
I'll do that, Your Honor. Thank you.
What's the next pretrial, Judge? I'm sorry.
January 24th at 8:15 a.m. Mr. Dagger-Mangosian, do you know if the transcript has been ordered?
I reflect that it has, but I guess we should check the court file. I believe it was ordered at the October pretrial.
Yeah, it should have been, Your Honor. I'm still going through the notes on the case, but if it hasn't, obviously we'll put the order in, but it should have been.
All right, I'll review the file. If I can't determine that it's been ordered, I'll order it, and we'll get that as quickly as we can. All right, anything else we need to address today, Ms. McClure or Mr. Dagger-Mangosian?
Your Honor, nothing on the file, but I'm just wondering if I can just pop into a breakout room with Mr. Lester just very briefly.
Yeah, give me a second. All right, Mr. Lester, I've sent you a request to unmute your device. If you will just.
I got it, man. Let me talk to my lawyer.
Can I hear you?
Just got back to
Okay. All right, Mr. Glazier, you ready to proceed with Mr. Johnson?
Yes, I am, Your Honor.
Okay, we are on record in file 23-21582-FH, People versus London, Lee Johnson. We are here today for an arraignment on a bench warrant for violating bond conditions, and we are proceeding today by video conference. Sir, you are London Lee Johnson?
Yes, sir.
Have you received a copy of your warrant?
Yes, sir.
The warrant alleges that you violated your bond conditions by failing to contact Mr. Coast in pretrial services and set up your twice weekly drug testing as required by your release conditions. The maximum penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines. You are entitled to have an attorney represent you with respect to this issue, as well as any other hearings we might have on this matter. Mr. Glazier has been appointed as your counsel on the underlying case. Do you want him to represent you with respect to this warrant as well?
Yes, sir.
All right, Mr. Glazier, you want to place your appearance on the record?
Yeah, John Glazier appearing on behalf of Mr. Lester, Your Honor.
This is Mr. Johnson.
Or, excuse me, I'm getting mixed up. Mr. Johnson. Sorry about that, Your Honor. Sorry about that, Mr. Johnson.
All right. So how does Mr. Johnson wish to proceed today?
Your Honor, when is his sentencing date set? I just got information that somebody at my house. I don't have his file.
Judge, I have a January 5th sentencing date.
Okay, thank you. Sounds like it's January 5th, Mr. Glazier.
Okay, Your Honor, we would ask, and I don't know if you need to move that sentencing or not, but we would ask to put this over to that date and ask the court consider releasing him. I've had a chance to discuss this matter with my client, and he can maybe tell you some more, but he wasn't aware that, and I know things happen fast at a plea, and he says he wasn't aware that he had to set up the the twice a day PBTs. He knew he had to pick up the police report or excuse me, the probation report and have contact with the probation department. And he was going to do that this week, I think. He can tell you, but he said he did make a call to the probation department and he wasn't told anything about the drug thing. If you would release him, he'll go over and talk to Mr. Coast today, get his probation report, and set up the twice a day drug testing. Is it twice a week?
Judge,
Yes.
we did have I had contact with Joanne Holly's probation officer. He did not show up for his PSI interview, so the report has not been completed.
All right, so that would run contrary to Mr. Glazer, what you just told me, but at this point, if we, I'm sorry.
I said Mr. Lester probably can explain it better than what I'm. It's one of those where it's going. Mr. Johnson. Mr. Johnson can tell you what happened.
After I ended our last court, at the end of our last court, I asked anybody, was anybody specific I was supposed to go see over there at the probation officer? No one said no. They said just go over there and just pick up the paperwork. I gave the phone number that I have to the household that I'm staying at, so I don't understand why I said they didn't give a phone number either. So both those things, you know, A said it was a rush to go get the paperwork or anything like that. So I'm not understanding what I failed to do. We get over there because the day I was released, I wasn't able to get over there at the time because I was released after the courthouse was closed. Then I missed Friday, so I'm gonna go the following Tuesday, following week.
All right, so at this point, I'm going to deny the request for a bond modification. Mr. Lester or Mr. Johnson has apparently not done his pre-sentence investigation interview, and he didn't set up the drug testing, which would have been explained on the record while Mr. Johnson was present. So I think we need to keep track of Mr. Johnson until our sentencing hearing and know where he's going to be until then.
Thank you, Your Honor.
I will set the contempt issue over to the sentencing date, Mr. Glazer, unless you want to have that, try to have that heard before. I don't know.
No, the same day is fine.
All right.
So you deny.
All right, Mr. Johnson, you can let the officer that's with you know that you're done with court for today.
So I'm not going to be released?
No, sir. Mr. Dagerman goes in call for Mr. Ridenour right now. Mr. Fry, are you ready for Ms. Walden's case?
Yeah, sure.
Okay. Yes. All right, Ms. Walden, are you there?
Yes, I am.
Okay, there we go. So we are on the record in file 23-21485-FH, People versus Kimberly Ann Walden. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Brian Fry on behalf of Kimberly Walden.
All right, and Mr. Fry, where do we stand with Ms. Walden's case today?
Yes, Your Honor. I think we had anticipated to have it resolved today, and I think that was Ms. Walden's anticipation as well. Unfortunately, Prosecutor Fleming is out today, and there's some communication issues going on. He did He did ask me to set this over until the next available court date. We should have it resolved then, you know, he'll be back, but we're gonna need a little more time.
All right, Ms. McClure, anything we need to address from the people's side?
Just that if you're looking to put it on the 27th, I know he'll be out that day as well.
About January 3rd.
That would work for me, Your Honor.
Okay, Ms. McClure, will Mr. Fleming be here that day?
Yes.
Okay, so we will adjourn it to January 3rd at 8:15 a.m. Mr. Fry, would you be willing to do a stip in order for that adjournment?
I will, Ms. McClure, can I send your name with your permission?
Yes. Just make sure our office gets a copy.
Yeah.
Okay, so Ms. Walden, your next date will be January 3rd at 8:15. You just need to log in with all the same Zoom information today.
Can I speak with my attorney, please, and run a breakout, please?
Mr. Fry, if you want to log in, or you can use the iPad out in the hallway, we can set up a breakout session for you.
I can just call you if that's okay. Let me just call you.
Yeah, I have a couple questions to ask you about. I never got my prelim. That's what I was concerned about. We had a deal with the prosecutor, and then he never went through with it. So I was wanting to know if maybe I could get my prelim back, because I never got a chance to have that.
Yeah, we'll talk about that. I'll give you a call right now.
All right. I actually could. There's another number I need you to call me on right now, please.
I'll just jump on Zoom.
Yeah, okay, so he's going to jump on Zoom so that you don't have to broadcast your telephone number, and I'll put you in a waiting room, or I'm sorry, in a breakout session with Mr. Fry as soon as he gets logged in.
Okay, thank you.
You're on.
Hello, it's Kelly and Judge Osipers. Could we have St. Ridenour in a room, please? Thank you. Bye.
Okay, Mr. Dagger Mangosian, we have Mr. Ridenour coming to us at the jail. Are you going to need a breakout session with him when he gets here?
I won't need a breakout session, but I will need to approach with Ms. McClure. So maybe we could just do that right now, honestly.
Yeah, so we can do that now if you give me just a second here to do everything I need to do.